You have two choices when you're charged with a criminal case. You either plead guilty or you go to trial, unless you have a brilliant lawyer who helps you get a dismissal or some sort of diversion, but that is not likely to happen in federal court. So you have two choices. You plead guilty, and sometimes we can get a charge or two dismissed, or you go to trial. And that is it. There's no in between. There's no pleading guilty with an explanation. In California, in Orange County, California, I should say, there's no such thing even as a no contest plea. And in federal court, there's definitely not any such thing as a no contest plea. So what does that mean? That means that when you get a criminal case, your lawyer will talk to the prosecutor and try to get you the best possible offer on your case. In state court, the offer is what it is. For instance, if the DA says, we're going to offer him 30 days, you take the 30 days. If you want to talk to the judge and get an offer from the judge, it may be less, it may be different. You may get a felony reduced to a misdemeanor. There are different ways of getting a guilty plea offer, either from the prosecutor or the court in state court. In federal court, you get an offer from the U.S. attorney. If you don't like it, you can plead open, which means you just plead guilty to all of the charges, and then you argue to the judge what the sentence should be, starting with the applicable sentencing guidelines. But I'll talk about that in the next video about pleading open. The point is that people want to negotiate. They want to say, you know, I don't want to plead guilty, but I don't want to go to trial. That's it. Those are your only options, unfortunately. If you go to trial and lose, generally speaking, you're going to get a higher sentence than if you take a deal. That's why it's called a deal. So I know a lot of people don't want to hear this, but that is the sad truth.